All right, calling cause numbers 36734 through 36741 on Lloyd Martin. Sir, are you Lloyd Martin?
Yes, Your Honor.
And Mr. Martin's here with his attorney, Mr. Burbank. Mr. Lesniak's here. The cases are set for trial to begin with jury selection this afternoon. Mr. Burbank filed a motion to suppress late last week, and I was given a copy of that video so that I could watch it prior to today to be prepared for the hearing. Is there any evidence that you guys want to present with regard to the motion to suppress, or do you believe I can make a decision based on the nature of the video? Mr. Burbank, Ms. Lesniak.
The way I read the motion, it was basically attacking, it sounds like, whether or not Mr. Martin was in custody at the time. I believe that the video kind of speaks for itself on that issue.
Mr. Burbank.
Now, I know for the
We
sake
would
of
have Mr. Martin, just one sentence, Judge, I could do it from here, whether or not he felt free that he could leave. But in a position, and also, Your Honor, in reference to my motion, kind of delved into, in reference to the crux of the matter, incriminating, non-incriminating, whatever you want to call the statements. So we believe it was a custodial interrogation.
Okay, Mr. Martin, raise your right hand, please, sir. Do you swear from the testimony you're going to give in this hearing and the trial, if you testify, will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am, Your Honor.
Thank you. Go ahead.
For the record, state your name, please.
Lloyd Thomas Martin III.
And Mr. Martin, you are currently under indictment in the cause numbers that the state just referenced. Is that correct?
Yes, sir.
I want to direct your attention to a video statement that was taken on May 27th of 2020. Do you understand that?
Yes, sir.
Speak up.
Yes, sir.
Okay. And do you remember being taken down, or do you remember giving a statement in the sheriff's department in reference to this incident?
Yes, sir.
During that statement, did you feel that you were free to leave at any time?
Not really. No, sir.
Well, not really,
No,
yes
sir.
or no?
No, sir.
Okay, so you didn't feel that and that it was a custodial interrogation?
Right.
And nothing further asked.
Mr. Martin, why don't you go ahead and come? It'll just be a little easier, I think, for the court reporter to hear you, for Mr. Lesniak to follow up. Come have a seat in the witness chair, please. Go ahead, Ms. Lesniak.
Mr. Martin, you're familiar with that interview. Have you seen it recently?
No, not recently.
Okay. How did you get to the police station that day?
I went there.
You drove?
Yes.
You had an appointment to go there?
Yes.
You're supposed to be around 11?
Yes.
Did police escort you to the police station?
No.
Were you handcuffed when you got there?
When I entered the building, yes.
And were those,
I do not know.
and were those handcuffs on you for the duration of the interview?
Once I entered the room, they took them off.
Okay. Did they tell you you were free to leave?
Not that I recall.
But they could have told you that you were free to leave. Did you sign anything saying that you weren't free to leave?
No.
Did you in fact leave at the end of the interview?
Yes.
Were you placed under arrest at the end of the interview?
No.
Were you handcuffed during the interview?
No.
Did they ask your consent for things during the interview, like your DNA?
Yes.
Did they ask you if they could see your phone?
Yes.
And did you have your phone there?
I didn't have a phone.
You said it was back at the house,
Yes.
and you'd have to go get it. And did they bring up a test for sexually transmitted disease?
Yes.
Was it your understanding you were going to go get tested for that?
Yes.
So you were going to go leave.
Well, they
to
took
be
a
tested.
swab right there, actually.
A DNA swab,
Yes.
not an STD swab.
Yes, they took that too.
Who took it? Did a medical professional do that?
They put me in a little room I mean, with a nurse like type thing.
And they took this swab for STD testing.
Yes. That's what they said they were gonna do, at least.
That's not on the video.
I don't know.
At any time, did you ask for a lawyer?
Yes,
Who did you want?
Burbanks.
And did they allow you to go get a lawyer if you wanted
They
to?
didn't allow me to call or nothing.
You didn't have your phone with you.
They didn't provide me a phone either,
Okay.
but I did ask for one.
And why didn't you end up with a lawyer?
Because I didn't feel like I did anything wrong.
Okay, so when you left, you didn't immediately call Mr. Burbank.
I think I did, yes.
Did any of the officers prevent you from leaving? Did you get up and say, I want to go, I want my lawyer, I'm gonna get out of here now?
I never said it like that, but I did say I wanted a lawyer and to speak with him before speaking with him.
Okay. Did they prevent you from leaving the room?
No, but it felt like I couldn't.
Did you drive home
Yes,
under your own power?
yes.
I'll pass that.
Just a couple questions. So when you went in, went to the police station, you were placed in handcuffs
Yes,
and then taken off at the time you watched the interview.
yes,
And at no time during the interview, you felt that you could leave,
yes.
nothing further.
Anything else?
No.
You can have a seat.
We rest, Judge. Based on, you have the tape.
Ms. Zelezniak, anything else?
I think the rest of certainly the interview is what it is, and it's, I feel like the officers in their duty interrogating the defendant made it seem like that he was in custody at all. He wasn't placed under arrest. He wasn't handcuffed during the interview. He arrived under his own power at an appointment time that he made with the consent of the officers. He left under his own power. It was not disturbing.
Right, based on the evidence as well, obviously I have recently reviewed the video and there was nothing in the video that made me believe that Mr. Martin, or that the officers made Mr. Martin feel like he was in custody. Again, he arrived on his own, he left on his own. They talked specifically about him calling back later at different times throughout the video to set up a possible polygraph, to get sexual testing for sexual transmitted disease that, as far as I could tell, did not take place. The only thing that took place that day was a swab of the mouth for DNA. And they talked about things like what movie he should watch that night. I can't even remember now what it was, but he hadn't watched a movie that they referenced, and they told him he should go home and watch it that night. So based on all of those things, I am going to find that it was a non-custodial interrogation, and the motions to suppress in each of the cases are denied.
Do you want to have me enter the video label it and enter it for the purposes of this hearing? I'll need to get a copy of it just so I can.
That probably for appellate purposes, that would be the best thing to do for purposes of the hearing. You can get that a copy on a break this afternoon or tomorrow morning. And we'll make that just, I'll admit, if you want to call it even courts one for purposes of the hearing, I'll have that in the record for everyone's sake. I wouldn't think there's no objection to that, correct, Mr. Burbank?
No, that's what I was going to request anyway.
Okay,
for
perfect.
purposes.
Okay, so I will get all those signed now. So is everybody prepared to move forward with trial?
Yes.
Ready? Any other pretrial matters that I need to take up before jury selection? I think I have a state's motion in limine that's been filed obviously some time ago, back in January of 2022. We can go through that. I want to make sure that there's nothing that's discussed, obviously, that shouldn't be in front of the jury during jury selection. Other than that motion, do either of you have any other motions that we need to take up?
That's none, Judge.
But we had filed a notice of intent to consolidate. I'm sure we're all aware of proceeding on all the cases. I'm not sure that that's been formally agreed on.
That I'm sure it's in here somewhere. Mr. Burbank, you've been made aware of that for quite some time, that they filed a notice to consolidate all of the cases, correct?
I have,
Do you have any objection to that? It's all the same.
it's all the same.
All right, so that,
Relative.
that will be granted and done. Other than anything else?
I think I need to print the attachment for the discovery certification, but we'll make sure we get that done.
Okay, if you'll make sure, Mr. Burbank, if you'll have your client sign the discovery certification now, and we'll get that attachment on it so that that's done before jury selection to show that you have received everything and gone over it. So on the state's motion, let me, do you have a copy of that
I do.
handy? Everybody's got it ready? Looks like paragraph 1. Any objection to that?
Unless I open up the door to this. Allegations, I'll approach before or.
Let's see an order. Okay. So that's specifically with regard to any reputation or opinion evidence of the past sexual behavior of the complainant or specific instances of past sexual behavior of the complainant. So I'll grant that. Obviously, if at any point either of you feel like that would become relevant or admissible, approach outside the presence of the jury. Number 2, any sexual behavior committed by the complainant after the date of the offenses alleged in the indictments. Mr. Burbank, any objection to that?
The same response, Judge. If they open up the door, I feel they open up the door, I'll approach or yes.
That's granted. So nothing's to be discussed about that without bringing it up outside the presence of the jury. Number 3 is whether the complainant has accused any other person of sexual misconduct. Mr. Burbank.
Same response, Judge.
All right, that's granted then. That's not to be discussed unless you approach ahead of time. Number 4, any alleged misconduct or extraneous bad acts or offenses committed by the complainant. Mr. Burbank.
I would hope during discovery that they've given us everything, Judge, but if not, we'll need to approach.
Okay. Is there anything specific that you anticipate on that?
No, Your Honor, the victim is
I've got it
juvenile.
right here. I've got it. I'm sorry. Go ahead.
The victim's a juvenile, so she doesn't have like any kind of criminal record, but I mean, she's, sometimes people try to muddy the water with all kinds of misbehavior that a juvenile might.
I mean, there are things obviously that were discussed by Mr. Martin on the video that have to do with some other things that she was accused of or some of her behaviors. I'm assuming other than those, that's something nobody's going to get into, correct?
Not my intention.
I mean, it's coming that part. If you introduce the video, then obviously it's coming in that way.
No, I understand that.
So what I'll do is grant number 4. If you think there's more information that needs to be gone into with regard to that or more evidence, Mr. Burbank, just approach before you do that. Number 5, any evidence of the character or reputation of the complainant other than for truthfulness or untruthfulness, Mr. Burbank.
Again, same response, Judge, if need be, or please open up the door. For testimony.
All right, then 5's granted as well with the same instructions. So that's it on that. So that means I've granted that. Today's the 17th. Sorry. Even had it paper clips so that I could see it. All right, anything else before jury selection?
From defense, Judge.
How long would either of you request for jury selection?
Probably about 25 minutes, maybe half an hour.
Okay.
Well, I asked all the questions, so I don't have to do that long.
All right, I mean, that's obviously that's not a lot of time, so I'll give you, if you get to 30, I'll let you know that you get to 30 and then we'll go from there. Okay, it's good with you?
Always good with me, Judge.
All right, so I'm gonna go off the record. Did I see you talking to Mr. Galmore